Live and direct, live and I take no jive.
Legalize it.
So how much can a koala bear? Koala bear, koala bear. Koala bear. Barry pulls a joint out of his pocket. Bill says, "Great, Barry, a reefer."
Hi, and welcome back to Koala podcast. I'm going to say it really quickly before I forget, speaking to Victoria Cvitanovic in New Mexico. We'd spoken before. She's a psychedelics lawyer. She works with Laura Ruddick, and she recently posted on LinkedIn about data privacy or privacy, however you pronounce it, issues. And I got in touch with her and said, oh, that's really interesting because I've not really heard anybody speak about it since about 2017, 2018, in the first round of Cannabis, where every time a state opened up on legislation, you seem to have to give away all your details before being able to buy one pre-roll. Things are a bit more sophisticated now. Victoria's going to talk to medical providers and the issues that there are with regard to data privacy. Sorry, Victoria, for the long intro. I just thought I'd sort of give an overview first. What led you to thinking about this in terms of, it coming up as an issue for you?
Thanks, Sean. First of all, thank you for having me. For those listening, my name is Victoria Cvitanovic. I work with Ruddick Law Group, and one of the things that we do is cybersecurity and data privacy law. I got to thinking about the intersection of my psychedelics practice and my data privacy practice through looking at some of the new legislation that's come out this past year. It's no secret that we've seen a torrent of psychedelic medicine-based and cannabis medicine-based bills around the country. And as I read more and more of them, it started to occur to me that a lot of these conflict with the provider's requirements under HIPAA and other state data privacy laws. Our most clear example that we have right now is this new bill that's working its way through the Iowa legislature. It's a psilocybin medical program, and there are a lot of really cool things about it. It's a bipartisan effort. It has passed the House with overwhelming support. And it doesn't do what a lot of the bills do, where they form a medical advisory board or a medical psilocybin advisory board and tell the rules later. This is launching with very, very detailed rules, all of which are great until one looks at the way that the data is required to be kept and given against who the providers are allowed to be. The Iowa bill contains this requirement that all of the psilocybin sessions under the program be recorded and be available for inspection upon request. It doesn't really lay out what a request is.
Inspection by whom? Do we know?
It looks like the state, but it's really broadly worded and it's confusing.
But I mean, if it's the state, they could then outsource it. I presume that's how a lot of these things happen, don't they?
I agree with you. The other problem with this record and inspect requirement, other than the obvious, what patient is going to want some of the deepest, most in-depth mental health work that they ever do recorded, there's also this issue with who the providers are. Under the Iowa bill, the providers would be licensed medical providers, people like MDs or advanced nurse practitioners, people who probably already have another medical practice. The way that HIPAA works in the United States under the high-tech amendments is like this. If you are a provider who takes insurance for benefits for any reason, you are a covered entity under HIPAA. Now, if you don't take insurance at all, you're not a covered entity, and your standards vary from state to state for what you have to do for data privacy. But if you're a covered entity, you're a covered entity. And offering another service, like psilocybin provisions, for which you can't get insurance reimbursements, doesn't change the fact that you are still a covered entity under HIPAA. So what we've done is set up a situation in which it's very difficult, if not impossible, for a provider to be both qualified to offer these psilocybin services and able to comply with the rules under HIPAA. It really narrows the pool of people who can be psilocybin providers under laws that look like this, because you either have to be someone who doesn't take insurance for any of your services, or you have to be someone who this is the only thing that you're doing.
Well, I mean, look, there's two states that are already doing that, Oregon and Colorado. Have you had a look at those and seen, because they're both actually tend to be fairly sensible about how they approach things. Did they look into this at all? Because I know, for example,
Absolutely.
in our preamble, I spoke about Oregon. I was there when they opened up medical, and yeah, as I said, they had to check everything before you walk through the door, but they pretty soon let that loose in cannabis. Did they consider that in psychedelics?
Yeah, so Colorado is actually a really interesting example of this. Within the United States, there's a lot of variance as to what the data privacy laws are state by state. We have some national laws, they're not as extensive as something like the GDPR in Europe, but we do have a lot stricter state laws. And Colorado has probably the strictest and most advanced state data privacy law of any in the country. So there's already a pretty sophisticated understanding of how data privacy interacts with every piece of litigation, or excuse me, of legislation in Colorado. It's not the same as some of these areas where data privacy is still developing. I also spoke with someone who was on the board that formed the rules for the Colorado Healing Centers. And he let me know that there was an intensive discussion of how data would be protected and what those customers were entitled to as they were forming the rules. So it's more baked in.
Yeah.
When we see bills like the Iowa bill that I'm using as an example, we see that there is this conflict that has developed, and it's unclear whether or not that conflict is intentional or whether that conflict is something that was maybe overlooked and is going to need to be worked out in the rules later. But either way, we're getting to a point where medical cannabis and medical psychedelic legislation is so common that we are going to have a significant number of providers who possess PHI, personal health information, on hundreds or thousands of people within a given state, and who are being told conflicting information about how they have to protect that data.
If you're an insurer and you have access to everybody's data at the moment, are the rules all the same with regard to the medicine or treatment that you are being provided? I suppose what I'm trying to get at is big companies love to get hold of data and then share it because they earn money from it. So are the rules set up in most states in the US already that it really doesn't matter what you're being prescribed or what you're being treated for, the data protection and privacy laws are fairly standard across the board, or does it, or have they split it? So if you get A, you have less ability to protect your privacy than if you get B.
So health insurers are covered entities under HIPAA, just like these providers that are using insurance are, just like what we call healthcare clearinghouses are. These are people who process data or process claims for health insurers or for providers. And there's another category that came in with the high-tech amendments called business associates. These are people who hold healthcare information, PHI specifically, sometimes ePHI, that are working for a covered entity. They are required to follow the rules colloquially referred to as the privacy rule and the security rule of HIPAA. And because of that, HIPAA typically preempts any state law that's not stricter than it. So we see fairly standard data privacy protections for health information that is held by people who are involved in using health insurance. Now, you asked if this is fairly standard across the board, and there's a way in which it is and a way in which it isn't. If you're using health insurance or if your provider accepts any form of health insurance, that's pretty standard. Any provider that accepts health insurance throughout the United States is going to be bound by those HIPAA rules. However, there are providers out there that don't take insurance for anything, even a typical physical or a routine blood work panel. If you don't take insurance for any reason, you are not a covered entity under HIPAA. That does not mean that you have no data privacy standards. Your state, especially somewhere like Colorado or New York or California, might have really, really comprehensive data privacy laws and cybersecurity laws that you have to follow. But the fact that you are opting out of taking insurance does change that HIPAA reliance that so many patients know the word for and feel safer because of.
And what about the discrepancy that any other treatment or product or drug is federally approved, essentially, but we're talking about two lots of compounds here that aren't federally approved, they're only state approved. Does that allow people who might think of ways to make money out of your privacy find a way through the courts to do so?
I don't even think it would need to go through the courts, depending on what state you're in and what the data privacy laws are that apply to every business or every person that's holding
Do
healthcare
those
data
state laws
are.
preempt any federal discussion with regard to the legality of cannabis and psychedelics?
Well, so the state laws are typically very general, right? It doesn't matter how you got that data, it matters that you have it.
Yeah.
So in those scenarios, yeah, your state laws are going to be the first thing that you need to look for and the first thing that you need to make sure you're compliant with. However, the fact that psilocybin or cannabis, which are often involved in these medical programs, are federally Schedule 1 drugs, does affect your privacy in that
Well,
typically
yeah,
there are
that's
no
what I was asking.
insurance reimbursements
Yeah.
available for these substances being prescribed. So even if you are going through your doctor or you're going through your cannabis pharmacist to obtain these substances, the fact that these substances are federally prohibited means that there's typically not insurance reimbursements for them. And so unless your provider is doing something else that takes insurance, that provider may not be covered by HIPAA. It's something that we all need to be thinking about as we advocate for this legislation. I see a lot of community support when I talk about psychedelics, and it's really cool to see. It's exciting. We see a lot of people show up and talk to their legislators in person when these bills are on the docket. We see people excited and happy and really digging into their community resources to come together for these bills. But when we do that, we have to decide, at least in my opinion, whether or not privacy is a community ideal or a community value. And if it is, we need to start building privacy protections into the bills that we're advocating for, instead of assuming that these other privacy protections are going to apply. Just like you've said, it's entirely possible that a lot of these providers are not covered by HIPAA because these are federally illegal substances for which there probably aren't many insurance reimbursements available. Like you've said, people are going to lose faith in a government that requires that their mental health sessions be taped and then available for inspection by who knows under what knows circumstances. It is, for me, a train wreck that's going to come to a head as the legislation gets more
It sort of
sophisticated.
dovetails with the current political thinking in the center of that classic less government. Less government in the US means more outsource. More outsource means going to more tech companies. More tech companies having your information means more of your information being shared. I mean, it's a pretty obvious set of steps if government is going to be smaller.
I certainly see that perspective. The other thing I worry about is we're trying to build confidence in this country in a medical system that is expanding into some substances that Americans have been told for generations are harmful and scary. And with building that confidence and building the body of research and building the number of people who are willing to take a leap on their problems and see if they can live better lives, we inherently have to consider what it is that we're doing to make people feel like they can't trust us as much. And one of those things, in my opinion, is data privacy. When we talk about cybersecurity breaches or data privacy breaches, what we often talk about is the number one cost of that happening to your business is the loss of your consumer trust. We've seen studies that show as much as an 80% drop in consumer trust after a business experiences a serious cybersecurity incident. So when we're developing medical programs that are inherently tied into services being provided to vulnerable people, these people are sick, they're disabled, they may be dying, they may be suffering from severe complex post-traumatic stress disorder. When we're talking about these vulnerable populations, especially, that data that comes from those sessions is especially, in my opinion, sensitive. And when we are advocating for legislation that directly contradicts how we would protect that data, it's a little frightening for those of us who want to build that trust.
So other people around the country in your profession, the legal profession, and also the medical profession, actually discussing this and working out plans of action to take to legislatures as they get excited by psychedelics and try and rush through pieces of legislation or not, as the case may be. Because until I read that exchange on LinkedIn a couple of weeks ago, again, I'm thinking about so many things, but that hadn't come to mind. So I presume for most, that it's an issue that people think is either being dealt with, or other people are thinking about it. Where are we in that process? And has anything gone to the courts yet about it?
So nothing's gone to the courts yet about it. I am expecting that we may see HIPAA preemption requests at some point, but I think there's a lot of nervousness around bringing like a HIPAA preemption request because of the fact that these substances are federally illegal, and by participating in these programs, anyone who's doing so is necessarily operating in opposition to federal law. So there's that kind of stopping people from doing anything about it. But the discussion is happening, especially in the states where the legislation being floated requires that any provider be someone who has a medical license or has a nursing license or has another license that's regulated by the state. People are looking at their practices and seeing how much they're taking insurance and whether or not their insurance business is something that they want to get rid of so that they can comply with these laws. We're getting a lot of client questions about it too. Like, wait, I thought you told me that HIPAA said this. How am I going to comply with that over here? And people are having to slowly but surely work out their compliance plans. There's a whole nother layer to this that's also starting to be discussed. And that is the argument that state health and human services departments are all covered entities under HIPAA. So if you are working in one of these programs that's overseen by your state's Department of Health and Human Services, are you necessarily a covered entity even though you're not taking insurance? It's an interesting conversation that I think is going to push privacy law forward in a way that cannabis and psychedelics advocates maybe didn't expect. I think that's a good thing. I think working these problems out is a good thing. But ultimately, I think we as advocates have a real responsibility to remember just how vulnerable a lot of the populations who benefit from these medical programs are. I'm also seeing a lot of people who look at these bills assume that HIPAA has it taken care of. There's this real kind of built-in American knowledge of HIPAA. Everybody signed a HIPAA consent form at the doctor. It's been around since 1997. It's one of these things that culturally people have a lot of acceptance for. There's this belief that my health information is private, and it's private because of HIPAA. There are huge misunderstandings in what that means and the circumstances under which your data is actually private that are problematic. And I think that that kind of cultural understanding that your health data is private because of HIPAA is leading a lot of people into a false sense of security when it comes to medical psychedelic or medical cannabis legislation.
Okay, I mean, okay, we've spoken about HIPAA. I'd like to just quickly also go back to sort of the part of the discussion about your data and being a recreational adult use cannabis user, because I'd say most states, when they set it up, every time you walk into a dispensary, you had to give over a lot of information. what's your knowledge about where we are now with that? How much have the states all come back on that and are asking for less information, or are they still sort of demanding quite a lot of information from people?
So I will say it varies extremely significantly from state to state and even between states' medical programs versus their recreational and adult use programs. I'm sure you may have seen that Stizzy experienced a
Yeah.
huge breach at the end of last year. We're talking about 380,000 cannabis users, passports, and age verification documents like driver's licenses being leaked. That compiling of data that has happened in the adult use, recreational use market is starting to get more attention after that breach. And there is kind of this bubbling discussion on whether or not collecting all of this data is riskier than it's worth when it comes to adult use cannabis. However, there has not been comprehensive legislation to get us to a point where we know what data we need and what data we don't need.
Okay, and I mean that was in California. Are certain states better than other states? I mean, have you done a compare and contrast at all?
So this is actually something I spend a lot of time thinking about. There are definitely states with more comprehensive rules, and then there are states with less comprehensive rules. There are also states that have rules that are more focused on business versus an individual user. And then there are states that take the perspective of the individual user being the most important and write their legislation from there. If you're looking for states with really sophisticated and frequently updated data privacy rules, you're going to be looking somewhere like Colorado, California, New York, Massachusetts. There are a few others that are also really comprehensive and kind of stacked in. But those are the immediate ones that I go and look at when I'm looking for an example of how to write data privacy into something like a contract.
Yeah.
If I had a client come to me and say, hey, what state do I need to look for if I want to have the most comprehensive data privacy plan that I can? I would probably have them look at Colorado, but of course, this isn't legal advice and it depends on their regular circumstances. Depending on their type of business, there might be a state that's a better model for them.
Do you have any idea how the Canadians dealt with this issue?
So I've looked a little bit of the Canadian versions of data privacy, and it's a lot more similar to the GDPR than what we have
Okay,
here.
so a little bit stricter.
A little bit stricter. For those of you listening, the GDPR is the General Data Protection Regulation. It applies to European citizens throughout the European Union, and it's
And
been a
it applies to
model.
people like me who try and read a US newspaper who refuse to have anything to do with it. So you just get a blank screen. But I
But
mean,
they've
sorry,
Yeah,
go
they've
ahead.
done a ton for us.
Yeah.
If you've ever had to opt into using cookies, that idea that you should know when someone's tracking you and be able to opt in or opt out of necessary tracking tools is from the GDPR. So it's done a ton globally to make data privacy better. It's also made it very difficult for people who are just starting out to build out their data privacy programs. So there are benefits and there are issues with having such a strict rule. I personally fall on the side of go on and build your data privacy program early in your business. Get used to operating in a data lifecycle way that's healthy and best practices, and let your customers know that you're doing that. It's a differentiator in what is an extremely saturated market. There are very few companies out there saying, we care about your data and we're making sure that we're keeping it for
Well,
as
I
short of
think
amount
yeah,
of time as possible.
most companies only care about it if they think there's a dollar to be earned from it, isn't it? Aren't they?
Exactly. So if you're looking for a market differentiator and you're a small business, this is one.
Well, Victoria, thank you very much because this is a big conversation, and you know, as I said, I think it was a sort of a little bit of a conversation prior to COVID, and then the Stizzy issue. But you've raised some really important issues with regard to, especially with regard to, providing health services rather than products per se. And as you say, it's going to be a discussion that grows and grows. and it's far more interesting than hemp beverages, I should say, at the moment, which everybody seems to be very overexcited by. Maybe they should make people register every time they drink a hemp beverage, because that would stop them drinking so many of them. Sorry,
And a lot of them are sold online, and a lot of people are agreeing to a lot of tracking to buy hemp beverages.
Well, I know. So, I think data privacy and cannabis and psychedelics is really important, because that's the same sort of information that can be used to do terrible things to people if the wrong people get their hands on that information, as you said earlier in the show.
Yeah, I'll close by saying this. Each one of these cannabis and psychedelics bills that we're looking at nationwide are the product of a dream. People came together to advocate for a better world in the way that they see fit, and that's really beautiful. I don't mean to disparage any particular bill or any particular group of advocates by saying that the data privacy element of this is something I'm concerned about. I see the progress, and I'm really excited for all of the people who've seen success as they've advocated for greater access to cannabis and psychedelics for those who need or want to experience that plant medicine. With that said, though, I think we do need to remember that data about ourselves is something we're constantly creating, and we might not want everyone to have it.
Exactly right. Well, thank you very much, Victoria, for being on the Karma Koala podcast. And I have a funny feeling we'll be revisiting this by